Let's go to Rule 111, that is the prosecution of civil action. But before I proceed, let me just say this. Thank you very much or daghang salamat for supporting my channel. And I rarely say this in my videos, no, that if you are watching right now and if you are not yet a subscriber, please subscribe naman to my channel or please like the videos and please leave your comments. Yung comments nyo napakalaking halaga because they give me that confidence, they give me that lakas ng loob to continue recording or to continue whatever it is that I am doing. And somehow it helps me, no, na there is someone out there, a law graduate or a law student or a bar review especially, who is listening to me, and I am able to help them understand especially itong mga rules ng criminal procedure and civil procedure kasi may pagka boring tong topic na to at hindi masyadong uh, masayang pakinggan. So let's start our lesson. Let's read section 1 of your Rule 111, the institution of criminal and civil actions. So when a criminal action is instituted, meaning to say, when a criminal case is filed, together with that criminal case is the civil case. Together with the criminal case is the civil case. And take note that this is only the general rule. General rule lang to ha, kasi there are exceptions, and the exceptions we are going to discuss that in the next slides. So again, when a criminal action is instituted or filed, the civil action shall be deemed instituted or shall be deemed included together with the criminal action. But what civil action are we referring to here? Anong civil action ba to? Recall your Article 1157 of the Civil Code. Nasa Civil Code tayo. One of the sources of the civil obligations of a person is delicts. Ano ba itong delicts? These are the acts or omissions that is punished by law. And itong sinasabi dito na civil action, this is the basis, this is the source of the obligation, because ang sabi nga ng Article 100 ng Revised Penal Code, if you commit a crime, not only are you criminally liable, but you also have your civil liability. So, meron kang dalawang responsibilities if you commit a crime. Criminal responsibility and civil responsibility. This is the basis of that civil action. Kaya a civil action will be filed together with the criminal action, and that civil action is for the recovery of the civil liability arising from the offense charged. So for the last time, when you file your criminal case, together with the criminal case is the civil case. But take note ha, that this does not happen all the time. This does not happen all the time, because if you are going to read your section 1 letter A, there is a word unless. There is a word unless. So ano ang ibig sabihin ng unless na to? It means that you can separate the civil action from the criminal action. You can separate them. Pwede mo silang paghiwalayin. So when does this happen? There are three scenarios, or there are three instances. And the first instance is when the offended party waives the civil action. So there is a waiver. Number two, when the offended party reserves the right to institute the civil action separately. So there is a reservation. And number three is when the offended party institutes the civil action prior to the criminal action. So the civil action was filed ahead of the criminal action. So take note of these three instances. So the first instance wherein the civil action is separated from the criminal action is when the offended party waives the civil action, meaning to say there is a waiver. So does this happen in real life? Answer is yes. Kung ikaw yung ninakawan and you saw that the accused has no means, kaya nga nagnakaw kasi walang pambili ng pagkain or walang pang tuition fee para sa mga anak. Kaya it would be useless if you go after him for his civil liability. But of course, gusto mo din naman makulong siya just to give him a lesson. Kaya ang ginawa mo, you waive the civil aspect. But what is the effect if you are going to waive the civil aspect? Section 16 of your Rule 110, we took this up already. If you waive the civil action, then you, offended party, can no longer intervene by counsel in the prosecution of the criminal offense. Kaya ano ang strategy mo if you are the private lawyer hired by the offended party? The strategy there is mag-claim ka pa rin ng damages. Kahit maliit lang, kahit 500 pesos, kahit 1,000 pesos, or 2,000, just for you to intervene. Otherwise, hindi ka na makakapasok dyan, mag-o-object na sa'yo si counsel ng accused or si PAW lawyer. So that is the strategy. The second exception is when the offended party reserves the right to institute the civil action separately. So, the offended party does not want the civil action to go together with the criminal action. So, in that case, offended party will make a reservation. Does this happen in real life? Answer is yes. Kasi minsan si offended party galit na galit talaga kay accused or gustong bigyan ng lesson si accused. So, gusto niya mas lalong mamroblema si accused, lalong maabala, lalong ma-stress. Kaya, offended party made that decision to file the civil action separately. So, question, when do you reserve the civil action? According to the second paragraph of your Rule 111, Section 1, letter A, you have to make your reservation before the prosecution starts presenting its evidence. So, usually during the trial to. Kaya as early as the pre-trial, kahit yung hindi pa nare-refer yung case for mediation or after mediation, dapat you have to manifest already to the court or you let the court know that you want a reservation of the civil aspect. But take note ha, wag kang maghinto dito that reservations should happen before the prosecution or before the fiscal starts presenting its evidence, but you have to make sure also that a reasonable opportunity was afforded to the offended party to make such reservation. Take note of the word used by the law, and. And one thing I want you to remember also is that yung reservation of the civil aspect does not happen all the time. You cannot reserve all the time because when you talk about BP 22 cases, pagdating sa BP 22, walang reservation. That is very clear according to your Section 1, letter B of your Rule 111. No reservation to file such civil action separately shall be allowed. The criminal action for violation of BP 22 shall be deemed to include the corresponding civil action. So, pagdating sa BP 22, itong BP 22, special to. Number 1, this is under the rules on summary procedure. Summary procedure, hindi siya regular procedure. At number 2, sino ang may jurisdiction? MTC. So again, pagdating sa BP 22, walang reservation, magkasama palagi ang criminal aspect at ang civil aspect. The third instance or the last instance wherein the civil action can be separated from the criminal action is when the offended party institutes the civil action prior to the criminal action. Very obvious naman yan, no, na you cannot join them together because nauna nang final ang civil action. Masyadong nagmamadali si offended party na i-file niya na agad ang civil aspect. So when that happens, nauna ang civil action. Civil action was filed ahead of the criminal action. Ano ang sinasabi ng rules according to Section 2 of your Rule 111? If the civil action is filed ahead of the criminal action, there will be suspension. Suspension of what? Suspension of the civil action. The civil action shall be suspended in whatever state it may be found before judgment on the merits. And take note take note that the suspension shall last until the final judgment is rendered in the criminal action. The suspension shall last until the final judgment is rendered in the criminal action. Baliktarin natin ang scenario. What if nauna naman final ang criminal action? Nauna final ang criminal action and there is an intention on the part of the offended party to file later the civil action. So in that case, if this is the scenario, make sure that you, offended party, make a reservation. Make sure that you make a reservation to institute your civil action separately. Bakit? Because again, the presumption of the law is if you are going to file your criminal case, together with that criminal case is your civil case. Kaya if you will not make a reservation, then you cannot file later your civil aspect. You cannot file it later kasi ang general rule is they will go hand in hand or they will be filed together. So if you have that intention to file later the civil aspect, you already made that reservation, ano naman ang sinasabi ng rules? In that case, your civil action, your separate civil action cannot be instituted because you have to wait until the final judgment has been entered in the criminal action. Again, after the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until the final judgment has been entered in the criminal action. So whether the civil action was filed ahead or it was filed later, take note na ang sinasabi sa atin ng rules is for us to wait. Wait on what? Wait until final judgment is rendered in the criminal action. Wait until final judgment has been entered in the criminal action before you can proceed with your civil action. Bakit? Because of the primacy of criminal action over civil actions. Take note of this. Although the rules is telling us to wait until a final judgment is rendered in the criminal action, but in an instance wherein the civil action is filed ahead of the criminal action, ang sinasabi sa atin ng batas na kahit suspended yan, meron ka pa rin remedyo or meron ka pa rin magagawa offended party because you, offended party, has that option to consolidate. You can move for the consolidation of the civil action together with the criminal action. What is the requirement for the consolidation? Number one, there must be a motion filed by the offended party. But you have to make sure that the consolidation will happen before the judgment is rendered on the merits in the civil action. And where are you going to file your consolidation according to your Rule 111, Section 2? You have to file this with the criminal action. You have to file this in the court trying the criminal action. So consolidation is allowed with the criminal action in the court trying the criminal action. And what will happen to the evidence that was already presented in the civil action? They shall be deemed automatically reproduced in the criminal action. However, even if they are reproduced in the criminal action, it is without prejudice to the right of the prosecution to cross-examine the witnesses presented by the offended party in the criminal case, and also without prejudice to the right of the parties to present additional evidence. And the consolidated criminal and civil actions shall be tried and decided jointly. Very clear according to the Section 2 of your Rule 111, second paragraph. Take note that the concept of consolidation can also be found in your Rule 31 of the Rules of Civil Procedure. But ito ang tandaan nyo pagdating sa civil procedure ha. Cases can be consolidated only when there is a common question of law or only when there is a common question of fact pending before the court. Kaya ang requirement is dapat there are at least two pending cases. And if there is at least two pending cases, kahit hindi or kahit walang identity of parties, kahit hindi common ang cause of action, as long as there is a common question of law or a common question of fact, then consolidation of cases is allowed. Let's go now to filing fees. So kung sa civil procedure, the rule is the payment of the filing fee is jurisdictional. How about in the criminal procedure? If you are going to file a criminal case alone, criminal case lang, without the civil aspect, then of course walang bayad. But kung merong civil aspect, the civil aspect is arising from delict, then we have to make a distinction. Kailan ba nagkakaroon ng filing fees? We have to differentiate. If what you are claiming in your civil aspect is actual damages, ano ang rule ng filing fees? And if what you are claiming is moral, exemplary, nominal, temperate, or liquidated damages, ano din naman ang rule pagdating sa filing fees. So we start with actual damages. So if what you are claiming is only actual damages, then there is no need for you to pay filing fees. Very clear under the rules that no filing fees shall be required for actual damages. Except as otherwise provided in these rules, no filing fees shall be required for actual damages. But again, this rule is not true all the time because pagdating naman sa BP22, sabi ko nga sa inyo, itong BP22 is a very special or peculiar case. Kasi pagdating sa BP22, kahit ang kiniklaim is actual damages, then hindi ito ang rule na nag-a-apply. Kahit mag-claim ng actual damages in BP22, there is a need to pay the filing fees. Very clear that the offended party shall pay in full the filing fees for the actual damages. And the basis of that actual damages is the amount of the check involved. Again, upon filing of the aforesaid joint criminal and civil actions, the offended party shall pay in full the filing fees, and that filing fees is based on the amount of the check involved, which shall be considered as the actual damages claimed. Again, the rule is if you are going to claim actual damages, then there is no need for you to pay filing fees. But if what you are going to file is BP22, then you need to file your filing fees. How about if what you are going to claim is no longer actual damages, but rather moral, exemplary, nominal, temperate, and liquidated damages. So in that case, you have to make a distinction. You have to make a distinction whether these damages are specified or not specified. Meaning to say, when you prepare the information, nakasulat talaga doon that yung moral damages is in the amount of 1 million pesos, or yung exemplary damages para wag nang pagtularan si accused is nakasulat ng 5 million pesos. Pag nakasulat, that means nakaspecify, ang sinasabi sa atin ng batas is that the corresponding filing fees shall be paid by the offended party upon the filing thereof in court. Again, where the amount of damages other than actual is specified in the complaint or information, then you have to pay the filing fees in the court or in the OCC. But if it is not specified, sinabi mo lang doon sa information that you are going to claim moral and exemplary, nominal, temperate, and liquidated, but you did not specify the amount, you did not put an amount, then what will happen? The filing fees shall constitute a first lien on the judgment awarding such damages. Take note that this rule on filing fees when it comes to moral, exemplary, nominal, temperate, and liquidated, pag pinag-uusapan again si BP 22, talagang very special tong si BP 22, the same lang, you have to differentiate again whether it is alleged ang ginamit dun sa rules or not alleged. Kanina, specified or not specified. Here, alleged or not alleged. Again, just like what I said, the same rules. If it is alleged, then the offended party shall pay additional filing fees based on the amounts alleged therein. Take note how we are talking about BP 22. This is under your Rule 111, Section 1, Letter A. And if it is not alleged, the same also, the filing fees based on the amount awarded shall constitute a first lien on the judgment. So saan lang nagkakaiba pagdating sa filing fees when it comes to BP 22? Nagkakaiba lang sa actual damages. Kasi kung sa regular criminal cases, walang bayad ang wala kang babayaran na filing fees for actual damages. Here in BP 22, you are going to pay in full the filing fees based on the amount of the check involved, which shall be considered as the actual damages claimed. If under Section 2 of your Rule 6 sa civil procedure, this was already asked in the bar examinations, if the pleadings allowed are complaint, counterclaim, cross-claim, third or fourth party complaint and intervention, take note na pagdating sa criminal procedure, counterclaim, cross-claim, third party complaints are not allowed. If you're going to read the rule, no counterclaim, no cross-claim, or no third-party complaint may be filed by the accused in the criminal case. So ano ang solution mo? What is your remedy? You can have your counterclaim, cross-claim, third-party complaint litigated in a separate civil action.